Unless you have any additional questions based on my final
No, I
comments.
appreciate that about unintended consequences there, but if there are no further questions from council, we would open this item up for public comment.
Thank you.
We're good? Yes, thanks. Any members of the public wishing to speak to this item, please come forward.
Good evening, Barry Levinson. As many of you do know, and some of you might not remember, because I don't believe any of you were on the board when this passed in September 2010, it was myself and my wife who spearheaded this law. And I think it's as important today as it is when it was passed. I have concerns. Even though at that time I was promised by the city manager and at that time the former city manager and former police chief that any adjustments to this law, we would, because of the nature of how much we were involved in it and spearheaded it, we would be informed. Neither my wife nor myself were ever called about this repeal. I think that's unfortunate. But what's even, I find, more unfortunate that I must disagree with the comments of both city attorneys, Mr. Touchstone and Mr. Jones. Everything that I have read, and let's look at the language here on the summary here on the agenda. A subsequent California Supreme Court decision finding blanket enforcement. The key word is blanket enforcement of mandatory residency restrictions to be unconstitutional, likely renders the remaining provisions of Chapter 7.150 unenforceable and subject to legal challenge. Blanket enforcement. I've read many of the case laws written, probably just about all of them, over the last 4 or 5 years, 6 years. And what they are comparing it to is not comparable. It's for almost every other law, with the exception of Fullerton, restricts all sex offenders of all types of people, both children and adults of all ages, from this residency restriction to be within a certain number of feet. In our case, 2,000 feet from a park, school, or nursery. All. Our law is specific. So as Mr. Touchstone says, we are dealing with specific registrants, only children, child sex offenders. There has been, as far as I know, no similar case law being struck down the way our law is written. And it was done that way when we talked about it at the time, when we talked about it with the assistant city attorney at the time, when we talked about it with Kevin Hamilton, who at that time is former police chief and was captain at that time. And all 4 of us, meaning my wife and myself, did they just put on the mic? Oh. All four of us at the time decided that it was smart to make it specific to the risk. And we wanted to make it the risk less. So any child, the reason they're striking down those laws is because somebody who attacks 50 or 60 or 30-year-old women is not a child sex offender. We picked out areas where there's children playing unaccompanied very often. And we wanted there to be a safe spot where children, convicted children sex offenders could not wander there and could not be watching them from their residency. So we didn't want somebody to move into a place. And by the way, I was on the Dr. Phil show, and there was an old man who was a child sex offender. And he said, if you're a sex offender and you don't want to reoffend, the urge is still there, but you don't put yourselves in harm's way. And that means if you're a child sex offender, you stay away from children. So no sex offender who has previously offended who wants to remain within the law would ever want to be at any place where there's children present, because that is a temptation, just like a former alcoholic doesn't go into a bar and spend the whole evening. So this law has not been challenged. I think this is putting the cart before the horse, and I ask you either to provide the evidence that the law that they're talking about relates to child sex offenders, and I believe it doesn't. Can I make one more point?
Please
summarize. Yeah, I will make it quick. A matter of fact, in one of the cases that I read, it specifically stated that the issue of whether it's restricted, like just to child sex offenders, has never been adjudicated. And the problem with the existing law was because it was blanket. Our law is not. So I ask you, please, reconsider, get all the facts before you move to make our children less safe.
Thank you for your comments. Any other members of the public wishing to speak to this item? Seeing none, I will bring the issue back to the council for discussion. Any comments?
Mr. Touchstone, if you could address the member of the public's comments with regards to blanket enforcement of all residency for all offenders as opposed to child sex offenders?
Well, with respect, I must disagree with Mr. Levinson in his comments. Specifically, I'm looking at the language before you right now of our municipal code.
Right.
It states that any sex offender, subdivision A, is prohibited from residing within 2,000 feet from any school, park, or daycare center. And then there is an exception for a sex offender who establishes residency prior to the effective date of this ordinance in 2010. The exception to the residency requirement does not apply if they were convicted of a registrable offense against a child. So in other words, the ordinance itself applies to all registered sex offenders. Subdivision C states that you don't get the benefit of the grandfathering clause if you committed an offense against a child. One other comment that I would like to make is that the residency restriction that was dealt with in San Diego was against parolees. These were, in other words, felons. These were sex offenders who were the worst of the worst. And in that case, even when they're being supervised by law enforcement after getting out of prison, the court still found that impinged upon their substantive due process rights and struck the provision down on that basis. Now, so I guess I disagree with Mr. Levinson slightly on his interpretation of blanket. He is correct that certainly that provision was to all sex offenders residing within the county of San Diego who were convicted of those felony offenses and were coming out of prison and on parole. So there is a slight distinction between the two. But I guess the point that I want to make is this: if the worst of the worst are having the ordinance, as in this case a state law provision, being overturned on unconstitutional grounds, I think that if anything, that weighs against the city in continued enforcement of its ordinance, which is more broadly drawn, does not necessarily apply to those who are convicted of felony offenses and so forth. So, and with that, I'm happy to any other follow-up questions.
I just have one more. It was also suggested that this is putting the cart before the horse, but in fact, we do have a legal challenge, Frank Lindsay versus the city of Fullerton, that was filed in September 2016.
That is correct, Councilmember Fitzgerald. In fact, that challenge is raising very similar grounds to what were raised in the N. Ray Taylor lawsuit. It's seeking injunctive relief against continued enforcement and having this ordinance on the book. And like I said, nobody is fighting this, which I'm not saying that should be the basis for the council's decision. If you choose to fight it, believe me, I'll go out there and be your advocate and so forth. In my legal reasoning and consideration of this, having read the case law, unfortunately the deck is stacked against us on these types of cases.
And wasn't it originally Jessica's law that put regulations on, about sex offenders on?
There's been a series of laws. Jessica's law, one of the ones most recently, that was in 2006, that adopted the residency restrictions, yes.
And then I think it was our understanding that where state law was silent, local jurisdictions could further regulate that.
Well,
which was
certainly that was the understanding, and in fact there's a provision of 3003.5 which states that there is nothing to prohibit a municipality from going forward and setting forth its own ordinance imposing additional residency restrictions, which certainly that was one of the things that we were operating under,
which is what we
back
pointed
in 2010.
to. Right.
And frankly, the explicit language of that ordinance seemed to invite cities to do this.
Absolutely.
Unfortunately, the legal challenge came down in the People v. Nguyen case, the People v. Godinez case, and specifically as to the city of Fullerton in 2013, the People v. Dermody case. Yep. And in that case, we had a decision that ruled against us, despite that explicit language saying, hey, you can do it. All the basis for those court decisions was we're still preempted by state law. So it kind of flew in the face of what all legal analysts who were looking at that thing thought we could do, and which is, I think, in large part what prompted the city to take the action that it did. Some of those decisions were, quite frankly, surprises to us in the legal community in light of that explicit language, and yet here we are.
Right.
And then,
I mean, that's why it's called the legal system, not the justice system, right? I mean,
well,
it's
I can't
absolutely
dispute that
ridiculous.
statement
The
with
state
you.
legislature certainly needs to do something about this.
I can't dispute that with you at all, Councilmember.
Mr. Touchstone, I had a brief question.
Yes, sir.
What was the penalty if somebody was to violate that code?
It was a misdemeanor violation, which is up to a year in jail, $1,000 fine or the maximums.
Was anybody ever convicted of that?
No. In fact, the People v. Dermody decision that I referenced was an attempt to prosecute an individual for being in a park who was at that time prohibited under the prior version of this ordinance from doing so. He was convicted in the trial court. Actually, strike that. He filed a demurrer, a motion to dismiss our case. My office was handling that prosecution. He filed a motion to dismiss the case against him, which was granted. We appealed it to the Superior Court Appellate Department, which ruled against us. That court ruled specifically against the city, not in a broad overall sense, but our ordinance specifically, that provision, the prohibition on being in a park, was preempted by state law. And from that decision, I notified the police department at the time, the chief at the time, and the city stopped enforcing that provision. The council subsequently repealed that provision of the ordinance as it existed at that time. We chose to leave in place, the council chose to leave in place what we have here today. And like I said, at the time when I spoke before you last, the In re Taylor case was up on appeal. The Court of Appeal had ruled against the municipalities there as well, or the state, I should say. The Court of Appeal had ruled that it was unconstitutional. However, that decision was depublished because the California Supreme Court had accepted it for review. That fast forward to 2015, that's when we have the decision that I've been discussing with you here tonight. All right.
One more question.
Yes, sir.
Are there any modifications or tweaks to this that you can think of that might still be considered constitutional and still afford the city some protection?
Unfortunately, I do not believe that we would be successful in amending the ordinance. I've taken a look at that issue, specifically some of the distinctions that Mr. Levinson brought up tonight, which I think are very good distinctions to raise, quite frankly, for consideration. However, based upon the prior Court of Appeal decisions on the preemption issue, I think anything we would do here tonight would be preempted, ultimately.
So any restriction that the city places on registered sex offenders would be considered preemptive to state law?
I believe that would be the ultimate decision based on what has gone on heretofore, as well as a potential determination that it might be unconstitutional as well, unfortunately.
Thank you.
All right. Anything else?
Yeah, so just to understand, so right now it's up. If we wanted to tweak or modify this law, we would have to go to our state legislator to change the ordinances of law, correct?
Well, what's before you tonight, Councilmember, is whether or not you wish to repeal the city's ordinance. So that is in your hands tonight. You could obviously vote an alternative motion to amend it in some way if you chose to do so. Like I said, I would do my best. I think ultimately I'm going to be back before you after expending considerable amounts of attorney's fees, both in amending your ordinance as well as defending the Lindsay lawsuit. If the city doesn't repeal the ordinance, then that stay is going to be lifted, and we will have to begin litigating and defending that lawsuit in federal district court. So ultimately, I think, frankly, that the best course of action would be for the citizens of California as a whole to broach this issue with the California state legislature and see what they could do about amending the penal code section in some attempt to work around the current Court of Appeal decision N. Ray Taylor and so forth. Whether or not that's been done, quite frankly, I haven't done the analysis on it. But I think if the state was acting on amending the penal code sections governing sexual convicted registrants, then you would not have the preemption issue at all because it would be the state enacting it rather than the city.
Yeah.
If that answers your question, sir.
Yeah. Thank you.
I move that Councilmember Silva goes home and talks to his wife, Assemblymember Silva, about changing this law to further protect the kids of our community.
I'll second that.
Aye. Any other questions? All right.
I see none.
Thank you.
No, you've been given an opportunity to speak. We appreciate that. Well, I would entertain a motion, or if there is further discussion among council members, we could do that.
Well, this is disgusting. Obviously, that the state courts have decided that communities can't take further steps to protect its citizens, especially its children. So I take absolutely no pleasure in repealing this ordinance. However, I will move that we do so.
I will second the motion, and if I may add a few words.
Please.
While some constitutional things make it difficult and you have to take actions that would be contrary to what you would really like to do, I took an oath to uphold the Constitution of both the United States of America and the state of California. It's clear to me the way we've written this ordinance, it is unconstitutional. And in keeping with that oath, I have to take that action. That doesn't mean we are going to be inactive in the future. Rather, we have a legislative platform that we work with our lobbyists, and I think we should encourage our legislator to enact what we're not able to do tonight and make that part of our legislative platform. And so that sometimes it's distasteful, but I do want to uphold the Constitution in all respects.
Were you looking to make that an amendment to the motion, or that was just commentary?
No, add it to the motion that we put
Well,
this
if
in
you'd
our
like-
legislative.
I was just
Yeah,
seeking
Platform, absolutely.
okay, all right, that we that the motion be amended to include in our legislative platform that we are working on and tweaking, that we encourage the legislature to enact a law to replace what we're unable to do tonight.
And the maker of the motion accepts that?
Absolutely. I think we need to do everything we can to make sure that our state takes this up.
Any other comments before I call the question here? Okay. There is a motion and a second on the floor. All in favor signify by saying aye.
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 Any opposed? Okay. Thank you. Unanimous. Item number 5, Sapphire Road, Fullerton Municipal Code, early morning parking. This from Public Works Engineering Division.
I would move the item.
I'll second it.
Okay, moved and seconded. Is there any additional
Public
discussion?
comments, maybe.
Public comments.
Okay.